Oregon's long-standing sanctuary laws, what they mean, how to report violations, and services for targeted individuals and their families. This presentation, including the slides, audio, and visual images, is owned by Oregon Department of Justice, or ODOJ, and is copyrighted. Any recording, distribution, reproduction, or alteration of this material requires express written permission from the ODOJ. The information provided today is for information only. It is not exhaustive and does not constitute legal advice. Not all content reflects the views of the ODOJ. To create agency policy or obtain advice regarding a specific communication or request from a federal immigration authority, consult your agency counsel. For information about your rights and legal options, consult an attorney. The ODOJ Civil Rights Unit did not write Oregon's sanctuary laws. ODOJ is specifically instructed under these laws to create a hotline to receive community reports of suspected violations of Oregon sanctuary laws. ODOJ, through its Sanctuary Promise Hotline, carries out this mandate under law.
We are all Oregonians. We love this state. We live, we work, we contribute, we play. We are community. We belong. Help keep Oregon a safe place for all. Oregon's Sanctuary Promise helps keep families together. In Oregon, state and local government, including police, are not allowed to enforce federal immigration law unless they have a court order signed by a judge. To report suspected violations, call the confidential Oregon Sanctuary Promise Hotline at 1-844-924-7829 or visit sanctuarypromise.oregon.gov. We accept all relay calls, available in more than 240 languages. You belong. Brought to you by the Civil Rights Unit of the Oregon Department of Justice.
You may have seen this public service announcement or PSA across social media, on TV, or on the radio. It is publicly available in multiple languages on our website at sanctuarypromise.oregon.gov and promesasanctuario.oregon.gov. This is our message to our communities about Oregon's sanctuary laws. We have tried to simplify some very complex and nuanced laws into digestible information. You are welcome to share the PSA with your community. As you saw in the PSA, Oregon's Sanctuary Promise Hotline is a place where community members can report suspected violations against sanctuary laws and learn about their options. Community members can call the hotline in any language at 1-844-924-STAY. Our Spanish direct dial line is 1-844-6-AMPARO. All of our advocates are bilingual or multilingual. We use a variety of language lines for interpretation into additional languages that we don't speak. We accept all relay calls. The hotline is staffed Monday through Friday from 9 a.m. to 5 p.m. and individuals can leave a voicemail after hours. Community members can also report online anytime at sanctuarypromise.oregon.gov or our Spanish language website at promesasanctuario.oregon.gov. Before we talk about Oregon's sanctuary laws, we need to understand the difference between federal government and state and local government. This difference isn't always clear to community members. Sometimes it isn't even clear to elected officials and other community leaders we speak to. The distinction is crucial to understanding sanctuary laws. In the United States, our federal government and our state and local government have distinct duties. The government is not just one big institution with roles and duties that are interchangeable. What can be confusing is that we have agencies within government with similar names. We have the United States Department of Justice, and we have the Oregon Department of Justice. We have a United States Attorney General, and we have an Oregon Attorney General. We have federal law enforcement like the Federal Bureau of Investigation, and we have state and local law enforcement like the Oregon State Police, or the Portland Police Bureau, or the Harney County Sheriff's Office. We have federal prosecutors at the U.S. Attorney's Office that prosecute federal crimes, and we have county district attorneys and deputy district attorneys who prosecute state and local crimes. While these government agencies may have very similar names, they have very distinct and different duties and jurisdictions. Oregon's sanctuary laws are about staying in your lane. State and local government and state and local police are to carry out state and local duties. Federal government and federal law enforcement are to carry out federal duties. In the United States, immigration enforcement is under federal jurisdiction, not state jurisdiction. So what is Oregon's sanctuary promise? Oregon's sanctuary laws say that Oregon state and local government, including state and local police, cannot enforce federal immigration law without an order signed by a judge. Oregon's sanctuary laws ensure community members can access vital state and local government services without fear that an interaction would result in their detainment or deportation. So, what is not covered by Oregon's sanctuary laws? Oregon's sanctuary law does not stop federal immigration authorities from conducting business, including enforcement and removal duties in our state. No state law anywhere in the United States can prevent federal immigration authorities from conducting business in their state. This slide shows some of the federal immigration authorities in Oregon. They have agents and offices all around the state that can and do conduct business lawfully in Oregon. These agencies include the United States Department of Homeland Security, U.S. Customs and Border Protection, U.S. Immigration and Customs Enforcement, or ICE, and U.S. Citizenship and Immigration Services, or USCIS. It is a common myth that individuals are safe from deportation in sanctuary states. Oregon's sanctuary laws do not stop deportations. No state law, including in Oregon, can stop federal immigration agencies from detaining individuals, from transporting and then holding them in custody, from starting removal proceedings in federal immigration court, and ultimately from deporting individuals from the United States. Most federal immigration arrests, detainments, or actions, including deportation, are civil administrative proceedings which are conducted by a civil administrative immigration judge. Sometimes there are federal prosecutions for federal crimes like unlawful entry or unlawful re-entry. In those situations, Oregon's local U.S. Attorney's Office charges individuals with these federal crimes in federal court, which can result in deportation from the U.S. upon conviction. There is no state law in Oregon or any other state that can stop either type of federal immigration actions. Information that was obtained or shared unlawfully in violation of Oregon's sanctuary laws cannot be taken back. Once shared, it can be used by a federal immigration authority to locate, detain, or eventually deport an individual. Once the toothpaste is out of the tube, so to speak, there's no putting it back in. Reporting a violation of Oregon's sanctuary laws and cooperating with the Oregon DOJ inquiry do not provide immigration relief or stop a deportation case from proceeding in immigration court. Many community members may know about a U visa or a T visa, which can provide temporary immigration relief or a temporary stay in the United States. These visas, issued by the federal government, are meant to encourage victims of violent crime to report to law enforcement and participate in prosecutions of those crimes. No state, including Oregon, has the authority to create these kinds of federal laws for immigration relief for cooperating with sanctuary investigations or any other reason. Recourse against violators via civil action does not come from the Oregon Department of Justice. The law was specifically designed not to be punitive, but rather to encourage state and local government bodies, employees, and officers to comply with the law. Communities have the power for recourse here. We will cover information about recourse in detail later in this presentation. Finally, Oregon's sanctuary laws do not mandate training for law enforcement or public bodies. Let's talk a little bit more about the history of Oregon's sanctuary promise laws. Oregon has the longest standing sanctuary laws in the nation. In 1987, Oregon became a sanctuary state under Oregon law, which passed by an overwhelming majority of both the Oregon House and the Oregon Senate. Only one person in the House and one person in the Senate voted against these laws. 10 years earlier, in 1977, two important things happened related to Oregon's sanctuary status. First, Oregon's then Attorney General James A. Redden issued an Attorney General legal opinion. While much of the information in the legal opinion is now outdated, there are two important findings that are still good law in the opinion. One, that state and local law enforcement agencies have no jurisdiction to enforce federal immigration statutes in Oregon. Also, Federal agents may not stop or detain individuals for questioning based on appearance. This is profiling. The second occurrence stemmed from a 1977 lawsuit. Delmiro Trevino, a United States citizen, sued the Immigration and Naturalization Service, or INS, what is now called Immigration and Customs Enforcement, or ICE, and several local law enforcement officers and agencies for profiling and harassing him. Out of this lawsuit, in 1978, INS stipulated that their policy does not authorize local law enforcement agencies to arrest people solely for charge of illegal entry unless INS officers are present. At that time, 10 years before Oregon law said so, it was clear that state and local law enforcement had a lane and federal immigration authorities had a separate lane. Furthermore, neither should be profiling individuals in Oregon. Since 1987, Oregon's sanctuary laws have been strengthened because of lawsuits, a failed ballot measure, and legislative updates. The laws continue to be backed by some strong legislators and committed elected officials. Oregon's sanctuary laws are imperfect laws with many gaps, some of which have no legislative fix. And yet they offer an important protection for community members in Oregon to be able to access state and local government services without fear that an interaction would result in their detainment or deportation. Even though some cities and counties have issued ordinances or proclamations to declare themselves a sanctuary city or county, in Oregon, all cities and counties are bound by state sanctuary laws. Let's talk about the law in more detail. In 2021, the Oregon legislature passed House Bill 3265. The governor signed the law on July 19, 2021. These are the elected officials who drafted and supported the bill. Elected officials are the people who anyone can contact to provide feedback or recommend updates to the law. House Bill 3265 updated Oregon's existing sanctuary laws, providing more specificity and detail about what is prohibited and what is required under these laws. Community members called the bill Oregon's Sanctuary Promise Act. The laws are now codified at ORS 181A.820 to 829, ORS 180.805, and ORS 180.810. The word sanctuary does not appear anywhere in the statutes. What are the key features? House Bill 3265 strengthened and clarified Oregon's sanctuary laws, outlining specific prohibitions on the use of Oregon state and local resources, which cannot be used for the purpose of enforcing federal immigration law. This bill created a statewide hotline for community members to report suspected violations of Oregon's sanctuary laws, learn about their options, and be connected to trauma-informed, culturally responsive resources. The Oregon Department of Justice conducts inquiries on behalf of the state into state and local public bodies and law enforcement agencies reported to have violated the laws. Remember, Oregon's sanctuary laws dictate what state and local agencies can and cannot do. These laws do not dictate what federal immigration agencies can and cannot do. As a result, ODOJ can only conduct inquiries about violations committed by state and local public bodies and law enforcement agencies. Suspected violations of Oregon's sanctuary laws are tracked by the Oregon Criminal Justice Commission, or the CJC. CJC uses de-identified data from the hotline as well as reports from state or local agencies when federal authorities try to obtain assistance, access, or information from them to enforce federal immigration laws that the Oregon sanctuary laws otherwise restrict or prohibit. The Oregon Criminal Justice Commission must publicly produce an annual report every July 1st regarding this data. Oregon's sanctuary laws provide a recourse avenue for community members, a private right of action to seek injunctive relief against public bodies or law enforcement agencies, ordering them to stop violating these laws. The law states, any person may bring a civil action against a law enforcement agency or public body that violates. Who must comply with Oregon's sanctuary laws? These laws tell three groups of people what they can or cannot do: state and local law enforcement, officers, and public bodies. Law enforcement includes county sheriffs, municipal or city police departments, certain university police departments, the Oregon State Police, and corrections officers. Officers are individuals who are employed or contracted as an officer at these agencies, whether they are on or off duty. This is important. It means these laws apply not just while the officer has their badge and uniform on, while they're out working in their patrol vehicle. They also apply when officers are not working, at home, on the internet, out in social situations, or whatever they're doing while off duty. An officer cannot meet up with a federal immigration agent and share information or engage in activities that violate Oregon sanctuary law. They must comply with the law at all times. Public bodies are defined as state government, local government, and special government bodies. This means state, local, city, county, and special government agencies, whether it's the city council of a tiny town of 18 people, or the public school district serving 200,000 students, or any of the 74 state agencies, or many county and city government agencies across Oregon. Remember, Oregon's sanctuary laws cannot tell federal immigration authorities what they can and cannot do. Who does the law impact? These laws impact everyone. The laws stand for safety, sanctity, dignity, and human rights of all individuals who live, work, or play in Oregon. Oregon is a better place when people can report crimes to the police, go to court to get a protective order, bring children to public school, get checkups or vaccinations in public health clinics, go to work, and otherwise participate in society, without the fear that every interaction with a state or local government official is going to result in a federal immigration authority being notified to remove them from the United States. There are individuals who are more vulnerable, including immigrants and refugees, asylees and immigration parolees, meaning people who are temporarily admitted to the United States for humanitarian reasons, people who hold a variety of visas, individuals who are undocumented or non-citizens, lawful permanent residents, DACA folks, and additional community members with vulnerable status. The next set of slides with a gold star in the lower right corner review broadly what Oregon's sanctuary laws prohibit. They are not an exact recitation of the law. Our aim here is to distill long, nuanced, and possibly confusing language into understandable information for our community partners. Each of these prohibitions and explanations of law violations has exceptions that we'll broadly cover after the starred slides. If you want an exact recitation of the law, please read the statutes at ORS 181A.820 through 181A.829, ORS 180.805, and ORS 180.810. There is also detailed information in our law enforcement toolkit at sanctuarypromise.oregon.gov under the Law Enforcement Bulletin. Let's review some broad violations of Oregon's law that state and local law enforcement and public bodies are prohibited from doing. 1. They cannot use state or local resources to help enforce federal immigration law. Resources including buildings, facilities, property, monies, equipment, technology, and personnel cannot be used to help enforce federal immigration law. 2. They cannot investigate or interrogate individuals for federal immigration enforcement purposes. 3. They cannot collaborate, support, or assist federal authorities for immigration enforcement purposes. 4. In most instances, they cannot ask about, store, or share information about a person's national origin, immigration, or citizenship status. Think about how a person with best intentions might write down, "This person is from X country," to be culturally responsive or remember some aspect of identity to help better interact with that person. In most cases, inquiring, storing, or sharing that information is in violation of Oregon sanctuary law. 5. Sharing additional information like custody status, release date, appointment times, home or work addresses, social media handles, school name, location or hours, workplace location and hours, email address, phone number, information regarding relatives or current or past known associates, for the purpose of immigration enforcement is unlawful in Oregon. 6. In addition, establishing traffic perimeters to support or facilitate federal immigration enforcement is unlawful in Oregon. 7. Civil arrest of an individual without a judicial warrant or order from a court facility, or while a person is traveling to or from a court facility when they are earnestly doing business in court, is unlawful in Oregon. This includes if they're in court testifying as a witness, supporting a family member who has a case, applying for a protective order, paying parking tickets, adopting a child, getting married, or doing any number of things that we may go to court for. Note that this provision may not be enforceable against federal immigration authorities. We often receive questions about sensitive areas. Other sensitive areas, such as schools, houses of worship, and hospitals, are not protected under Oregon law. As of January 2025, federal immigration authorities may seek to take actions in sensitive areas like schools, houses of worship, hospitals, and courthouses. On January 20th, 2025, the federal government rescinded an October 2021 U.S. Department of Homeland Security policy memo that protected certain essential service areas, such as schools, houses of worship, hospitals, and courthouses, from immigration enforcement, replacing it with a directive that gives ICE agents authority to take enforcement actions in any of these spaces. 8. Denying services, benefits, or privileges to a person in custody or who is on probation, parole, or post-prison supervision based on that person's immigration status is unlawful under Oregon law. For those who have done work intersecting with the criminal justice system, you may remember that before April 2014, we used to see something called an ICE hold on various jail inmate rosters, reflecting civil administrative detainers. Due to both this Oregon law as well as an April 2014 federal court ruling by Judge Janice Stewart called Maria Miranda Olivares versus Clackamas County, if a person posts bail, Oregon jails cannot hold the person for federal immigration authorities due to a civil detainer or hold. 9. When someone is detained, law enforcement is required to provide written notice translated into the person's language upon request that the person has the right to refuse to disclose immigration status, national origin information, or citizenship information, and that if they choose to share that information, it may result in civil or criminal federal immigration consequences, including deportation from the United States. 10. Granting a federal immigration agency access to a private area of a facility for federal immigration enforcement purposes is unlawful in Oregon. This includes jails, private back hallways or private elevators in the courthouse, doors or spaces requiring a key fob or a badge swipe to enter, private back sally ports, and even office spaces where reception must grant an individual access. State and local government offices and law enforcement agency facilities cannot grant access to all those private areas for the purpose of federal immigration enforcement. 11. State and local law enforcement and public bodies cannot enter new or renew existing formal or informal agreements with federal immigration authorities, giving them federal immigration enforcement powers or detention powers. Again, individuals cannot be held in custody on those civil ICE holds. 12. Oregon law prohibits the operation of a private detention facility for immigration enforcement purposes in our state. If an individual is detained by a federal immigration authority in Oregon, they're typically transported immediately up to the Tacoma Detention Center. 12. Finally, failing to document or report to the Oregon Criminal Justice Commission any attempts or communications by federal authorities to obtain assistance or information for immigration enforcement purposes, all the things reviewed in the previous slides, like gathering information, accessing private areas, holding people on civil immigration detainers, and more, is unlawful in Oregon. Requests made to public bodies for assistance or information related to immigration enforcement must be reported to the Oregon Criminal Justice Commission at least monthly. There are lots of exceptions to these laws. We'll provide some examples of these exceptions. This is a non-exhaustive list. 1. Inquiring about or collecting information about an individual's national origin, immigration, or citizenship status may be allowed if that information is necessary to advance an investigation into a state or local crime. Think about the crime of human trafficking. A law enforcement officer comes upon a field and there are a bunch of people working in the field in poor conditions. The people working don't speak any English. They don't know what town or state they're in. They don't have any phones. They don't have IDs, and they don't know what time or day it is. These are flags or signs of potential human trafficking. It may be important for law enforcement to advance an investigation into this state crime to inquire about where the individuals have come from. If that is one of the elements of the crime, and it may be necessary to advance the investigation into the crime. Law enforcement is not prohibited from asking questions of this nature in all circumstances. 2. The second exception is if the information is necessary to determine eligibility for a benefit the person is seeking. An example is if the crime victim is asking a judge, Oregon DHS worker, prosecutor, or law enforcement officer to sign a U or T visa. We've discussed that U and T visas can provide temporary immigration relief or a temporary stay in the United States to encourage victims of violent crime to report to law enforcement and participate in prosecutions of those crimes. If a victim or their attorney asks one of these state or local employees to sign a certification for a U or T visa, they may need to store those documents associated with the case, and this may not be a violation of Oregon sanctuary law because someone is seeking a benefit. 3 and 4. Another exception under Oregon sanctuary law is if there is a judicial subpoena or an order signed by a judge or some other compulsory court-issued legal process that requires the question to be asked or the information to be stored or the information to be shared. These would be exceptions to the law. 5. A fifth exception is if there is a state or federal law requirement to do or not do something in conflict with the broad sanctuary laws. To be clear, when we say federal law requirement, this does not include enforcement of federal immigration law. An example is when someone goes to the DMV to get a license. A person has a number of license options. Under state and federal law, there are requirements to provide a birth certificate, a passport, or other proof of citizenship to obtain a real ID compliant license. Because of these state and federal law requirements to ask for such information, and for DMV to share such information, this may not be a violation of Oregon sanctuary law. 6. A sixth exception applies only to public bodies or law enforcement agencies that have detained a person. If the information the federal authority is seeking about the in-custody individual is already available to the public, it can be shared with the federal authority in the same manner that the public would have access to the information. An example is jail rosters that contain release dates. A member of law enforcement or jail staff could share release date information with a member of federal immigration authority in the same manner that they offer information to the public. If the jail would normally say, "Yes, we have that information, go check the website," to a crime victim who calls inquiring about a release date, they may be able to say the same thing to an ICE agent, but not tell them the actual release date since they wouldn't do so for the member of the public. However, if the jail would normally say, "Yes, we have that information. The release date is June 1st," to a crime victim who calls in inquiring about a release date, they may be able to say the same thing to an ICE agent. In summary, the jail may be able to provide that information to a federal immigration authority, not violating Oregon sanctuary law, if they provide the information in the same manner to the general public. 7. Finally, a law enforcement agency may exchange information with a federal immigration authority to request criminal investigation information about persons named in records of the Federal Immigration Authority. The law enforcement agency cannot make this decision on a random, minor crime simply because of the suspect's race, skin color, name, accent, or spoken language. This would be profiling. The law enforcement agency would need to be able to make a connection as to why that information exchange is necessary in this particular case. As a recap, the laws are complex and nuanced. This presentation is not legal advice. Contact your agency's attorney for analysis and advice on scenarios specific to your agency. What type of recourse is available under these laws? We've discussed that these laws allow any person to bring a civil action, also known as a private right of action. Under the law, a person includes a targeted individual, their family member, an unrelated community member, a community nonprofit agency, or even a corporation. However, it does not include the Oregon Department of Justice. The private right of action allows any person to seek injunctive relief, which is an order from a judge saying, I see what's happening. It's a violation of Oregon law, and I'm ordering you to stop violating the law and to follow the law. Another avenue for recourse is a tort claim under Oregon or federal law. This means individuals can sue for injuries and damages caused by a government agency. In simple terms, recourse includes asking a judge to order the public body to stop violating the law and/or suing the public body that violated the law. Both options are available. Remember, neither the injunctive relief nor the tort claim have an impact on a person's immigration case. These lawsuits do not unwind a person's detainment or deportation, and the information shared can still be used against the person by federal authorities in a federal immigration case. In 2023, the Rural Organizing Project and the Community Alliance of Lane County pursued that private right of action outlined in Oregon's sanctuary laws. They brought a lawsuit against the city of Cottage Grove and the Cottage Grove Police Department. These two community-based agencies were aware of conduct they believed to be in violation of Oregon's sanctuary laws. The case resolved with what's called a stipulated judgment, meaning all parties agreed to the outcome of the case. The judge signed an injunction, and the judgment says that the city of Cottage Grove failed to comply with Oregon's sanctuary law. In fact, their policies, practices, and actions violated Oregon's sanctuary law. As a result, they are permanently prohibited from disclosing information to enforce federal immigration law, and they are permanently prohibited from using resources to enforce federal immigration law. In other words, they are permanently required to abide by Oregon's sanctuary laws. Out of the judgment, the city now has a new immigration policy which complies with Oregon's sanctuary laws. Any change to this policy requires notice to these community organizations. Also outlined in the judgment is that all city staff, including police officers, must undergo annual mandatory training. The Cottage Grove Jail is now closed. This is where a lot of the sanctuary law violations were occurring. Any change to the jail status requires notice to these two community organizations. You can see that there were some very significant systems changes from this case, which shows how powerful that private right of action and injunctive relief can be systemically. The judgment is posted publicly on our website. The law provides broad messaging to Oregon state and local government agencies and law enforcement agencies. First, public bodies are encouraged to have confidentiality policies modeled after the Attorney General's Office model policies to limit to the fullest extent possible, consistent with state and federal law, immigration enforcement at public schools, public health facilities, courthouses, public shelters, and other public facilities operated by a public body. The intent is to protect information and help keep places like healthcare facilities, public schools, community resource centers, and victim service centers, places where folks can safely seek services. If the public body has these confidentiality policies, the law says that they are required to review and update their policies annually. Second, every public body is required to have internal procedures to instruct its staff on what they must do if and when a federal agency does make a communication or request relating to federal immigration enforcement. If a federal agency comes up to a receptionist at a public body without judicial subpoena and asks for information, access, or assistance for the purpose of enforcing federal immigration law, that receptionist will know their internal procedure and what they are required to do according to Oregon law. Note that a request or communication could come from a federal immigration agency, like ICE, or it could come from another federal agency that has been temporarily deputized to do immigration enforcement work. The request could even come from a contractor doing federal immigration enforcement work. It's important to understand and clarify who is asking and what the purpose of the request is for. According to Oregon law, if a federal agency makes a communication or request that relates to immigration enforcement that is not accompanied by a judicial subpoena, the Oregon state or local public body must deny the request, document the request, and report it internally to their manager or agency director. The manager must report it to the Oregon Criminal Justice Commission at least monthly. Deny, document, report internally, report to Oregon CJC. If you are an employee of an Oregon state or local public body and you don't have a copy of your agency's internal procedure, ask your manager. There may be agency-specific details like We will always contact our attorney to evaluate paperwork or documentation submitted. Just as there is broad messaging to public bodies and law enforcement agencies, we have important takeaways for community members to remember. Let's review them. Oregon state and local government must stay in their lane. Remember, Oregon state and local government, including state and local police, cannot enforce federal immigration law without an order signed by a judge. Report. If you believe a violation of Oregon's sanctuary laws has occurred, report it to the statewide Sanctuary Promise Hotline. There are limitations to Oregon's sanctuary laws. Violations do not change a person's immigration case. There are recourse options. If you want to make systems change, Oregon DOJ can investigate, and any person may bring a civil action or a lawsuit against a public body or law enforcement agency that violates. Remember, community members have options if they believe a violation of Oregon's sanctuary laws has occurred. Individuals do not need to investigate, study the law, or know for sure if the conduct was in violation of the law. Oregon Department of Justice operates the Sanctuary Promise Hotline for community members to report suspected violations of these laws and walk them through their options. Community members can call the hotline in any language at 1-844-924-STAY. Our Spanish direct dial line is 1-844-6-AMPARO. All our advocates are bilingual or multilingual. We use a variety of language lines for interpretation into additional languages we don't speak. We accept all relay calls. The hotline is staffed Monday through Friday from 9 a.m. to 5 p.m., and individuals can leave a voicemail after hours. Community members can also report online anytime at sanctuarypromise.oregon.gov or our Spanish language website at promesasantuario.oregon.gov. What happens on the hotline? We outline in detail on our website what community members can expect when they contact the hotline. To review the process briefly now, a live hotline advocate will generally follow this process. Welcome. The hotline advocate will share their first name, ask about any accessibility needs, and inquire if an interpreter is needed. The hotline advocate reviews our informed consent information to make sure that individuals are making an informed decision about engaging with us and understand our role and limitations. We explain our obligations related to mandatory reporting, information collection, and attorney-client representation. Next, advocates focus on finding out what happened. They ask questions like who was targeted, when, where, what state or local agency was involved, and what federal agency was involved. Advocates then focus on safety planning, resources, and next step options. They offer to connect individuals to local community agencies that can help, attorneys who can assist with filing for injunctive relief or pursuing a tort claim, and immigration attorneys. Oftentimes, they're hearing from the loved ones of an individual who has been targeted and detained, and they can provide resources and support to family members and witnesses in addition to targeted individuals. Advocates will ask, what is the caller's goal for the call? Are they interested in an inquiry by the Oregon Department of Justice on behalf of the state? Do they consent to an investigation? A person does not have to consent to an inquiry on behalf of the state. A caller can ask that ODOJ simply provide resources or collect the data. We stay in touch with folks throughout the Oregon DOJ inquiry, including providing support through any investigative interview, and let folks know at the conclusion of any ODOJ inquiry. Sanctuarypromise.oregon.gov takes individuals to this landing page full of information, resources, and guidance. Clicking the hotline button provides details about the hotline, what happens on the hotline, resources for those targeted, and data. If you click Make a Report, this button takes you to our online web portal reporting form, where any community member can report suspected violations online and ask for a call from an advocate. Here is what our online reporting form or web portal looks like. The starred fields are required. The form requires certain limited information, including the name of the targeted individual, their language, if they're in custody somewhere, if they have an attorney. The form asks what happened, when and where, who was involved, which law enforcement agency or public body may have violated the law, and which federal agency was involved. Finally, the form asks if the person wants a call back from the hotline. If the person indicates they do want a callback, the form asks about the relationship of the reporting party to the targeted individual. The reporting party is not required to provide their name or contact information. They can make a report anonymously. However, if the intention of the report is for the state to open an inquiry, most often an anonymous web report does not include sufficient information to allow ODOJ to do so. Providing a callback number in the form or making an anonymous phone report allows ODOJ to ask follow-up questions necessary to open an inquiry on behalf of the state. Back on the main website, the Sanctuary page offers links to the Attorney General's model confidentiality policies for public bodies, information for hospitals and public schools, and a detailed law enforcement toolkit. The website links to our outreach materials and information, including our brochures, flyers, and outreach cards, our public service announcements for TV and radio, and social media options that anyone can use to share information about the law and hotline with their networks. Our outreach material is available in English, Spanish, Quiche, Mam, Mixteco Alto, Mixteco Bajo, Puripacha. Everything on our outreach website is downloadable and reshareable. Please share these materials across your networks and with your community members. On our website is an important resource called the Community Toolkit. It includes the information that we reviewed today, what sanctuary law is and what it is not, how to report to the hotline, what Oregon DOJ inquiries look like, and information on sensitive areas. The Community Toolkit has immigration resources, including attorney options. It includes materials from community partners about family preparedness, having a plan that everyone in your family knows, and even legal paperwork to ensure children stay with a known trusted person if a parent is detained. This toolkit has information from partners about knowing and understanding your rights. It includes videos and written materials about what to do if ICE is at your home or if there's a workplace raid. These Know Your Rights materials are available in many languages, including English, Spanish, Chinese, Korean, Arabic, Russian, Tagalog, Haitian Creole, Vietnamese, and Hmong. There are links to red cards from Immigrant Legal Resource Center to help people assert their rights and protect themselves in many situations, and resources to report and request rapid response about federal immigration authorities active in your community. Rumors and misinformation spread quickly and cause panic, so community agencies have rapid response systems to verify if information is accurate and help with safety planning if federal authorities are detaining someone or raiding a workplace. The Sanctuary Promise Hotline is not the best place to call to report ICE activity. If a person believes that state or local law enforcement or government may be assisting ICE in violation of Oregon sanctuary law, then the hotline is the appropriate place to call. We encourage you to check out the Community Toolkit as there is a wealth of information included. The Oregon Attorney General, through the ODOJ Communications Director, publishes regular media releases about work the Oregon Department of Justice is doing beyond the Sanctuary Promise Hotline. Sign up for notice on the Oregon AGO Media Releases page. For media inquiries or to reach the Office of the Attorney General, please contact Oregon DOJ's Communications Director at 503-378-6002. You are welcome to follow us on social media or sign up for our newsletter. Community members are always welcome to contact the hotline to ask questions or staff a possible violation. If you are a public body or law enforcement agency and have systems or policy level questions, please contact our front desk at 503-378-6324. Please note that we cannot provide any legal advice. For legal advice, please contact your agency counsel or attorney.